Having a case dismissed at the CCMA is cause for relief for employers as responding parties. But does it mean that your case has really gone away? This is stuff employers should know.
Welcome to Stuff Employers Should Know, the podcast navigating the legal complexities of South African employment and labour laws. Proudly brought to you by LabourNet, management's ultimate HR solution.
Welcome to this week's podcast. I'm Barry Gordon-Davis, and I'm joined by the level manager and producer, Yasser Is. I live my life a quarter mile at a time.
Yeah, family is really important to me. I see you have a copy of the Labour Relations Act with you today, so things are getting pretty real.
Not only a copy of the Labour Relations Act, but I'm also armed with some case law as well today. I'm going to try and keep it as simple as possible, but yeah, a big one. You know that feeling that you get when you're on a low-cost airline, and I know most of us haven't, and I know I haven't personally in the last 2 years, but you get onto the plane and it's generally full to the brim. You get seated, got your nice window seat if you've pre-planned, and there's nobody next to you. That nervous feeling of watching everybody come up and hoping that you're going to get nobody next to you so that you can have this flight wherever you're going with nobody next to you.
Whoa,
you're already visualizing having all the space and elbow room on your flight. You know that feeling.
Unfortunately, I've only dreamt of such, Barry. I've never ever really experienced it. And every time that I thought I would, I'd wake up from that lovely dream and someone would pitch up next to me.
What do you mean? There's always somebody on the flight next to you.
Every single time.
I've been fortunate enough that I've had those ones where they say, cross-check, we're pulling back now. There's nobody there. But I've also had those ones where that person is literally the last one on the plane and literally the last one trying to find their seat. And they're looking at their ticket, looking at you, looking at that ticket. And you say, please go past. And then they say, oh, no, wait, this is my seat. Please help me with my seatbelt. We can't even fit in the same row together.
Oh, the joys of flights.
Well, you get that exact same feeling at the CCMA. The scheduled time for a matter passes. You're sitting there waiting for them to call out your names that you're going to attend a arbitration, and the applicant hasn't arrived, or the referring party hasn't arrived. The other party hasn't arrived, and you know that they're going to give them 30 minutes. And if they fail to arrive within 30 minutes, the matter is going to then be dismissed. That's that exact same feeling of anxiety. So today we're talking about the dismissal of matters before the CCMA, specifically because of non-attendance by a party. So when a dispute falls under the jurisdiction of the CCMA to be arbitrated, it can occur, and it does occur quite often, that the applicant or the referring party or the employee may not arrive at arbitration, or the responding party, or generally the employer, does not arrive, and sometimes even both. But let me start with the respondent failing to appear. So in terms of section 138, subsection 5, paragraph B of the Labour Relations Act, if the respondent or the responding party fails to arrive, the commissioner can do one of two things. They can either agree to postpone the matter on another date, or they will arbitrate in the absence of the other party.
Are you trying to say if it continues in the absence of the respondent, they only hear one side of the dispute?
Precisely. They will go on with the matter in the absence of the respondent, which means that they will only take the version that is given by one side, being the applicant or the employee in the side, and that generally leads to a punitive award against the respondent or the employer in that stage.
And that would mean the employer now has to comply with that award?
Well, the employer is bound by that award, and the award stands, and it is enforceable unless the respondent then applies for a rescission of that award, which is where they go and show good reason why they did not attend the set down arbitration in the first place. They have 14 days to put in an application as such. However, if they are past the 14 days, their application must be accompanied by a condonation application, basically demonstrating a good reason why they were late and a good reason showing why they then did not pitch for the arbitration as it was set down.
Oh, Barry, you're making me a little bit dizzy with all of these processes. So what happens with those applications?
So when they apply for a rescission application, the commissioner will then make a ruling on either rescinding the matter or not. If the rescission is granted, the matter is then set down again for arbitration. If not, the employer is then obviously bound by that award.
And if the applicant or employee fails to arrive for the arbitration, then what?
Cool. So on the other side of the scale, so if the respondent arrives, but the applicant does not arrive, then again, in the terms of that same section, just a different paragraph, being section 138, subsection 5, paragraph A of the Labour Relations Act, it states that if a party, which is the referring party, fails to be represented or fails to arrive at the arbitration proceedings, the commissioner has the powers to dismiss the matter. So, in practice, this has always taken place in the form of the commissioner issuing a dismissal ruling when the applicant party has failed to appear for the matter. And then the applicant, just like the respondent, would then go through the whole same rescission process. So, what I've gone through now is effectively the common procedure, or what used to be the procedure at CCMAs across the country. However, in a recent Labour Court cases, specifically that of Glencore Operations SA versus the CCMA and Others, as well as Solomons versus the CCMA and Others, and I'll give the full citations of these case laws in the description of the podcast, the Labour Court provided new guidance and guidelines on the dismissal of matters by commissioners, specifically in terms of section 138, subsection 5, paragraph A of the Labour Relations Act. Now, what's interesting to note is that both those case laws that I'm going to be going through briefly of each, and I don't want to go too deep into them, but I'll go obviously with the crux of them, they were both done by Judge Moshuana. The significant consequence of these two cases is that it's now actually led to a directive being issued by the CCMA to all its commissioners, and specifically changes the way and manner in which the CCMA now deals with the dismissing of matters, specifically due to the non-attendance of the referring or applicant or employee party. So, let's get into the background about what brought about this Labour Court judgment. Specifically going through the matter at hand that happened with Solomons versus Food Lovers Market. And we'll just refer to it as the Solomons matter. And we must note that in the Solomons matter, when we get into the Labour Court area, there's going to be multiple references to the Glencore matter. And I'll refer to it as that. But we know that the CCMA's primary function is to resolve labour disputes. Specifically in the context of arbitration, the commissioners are given guidance through the Labour Relations Act, which basically says that they are there to determine disputes fairly and quickly and deal with the substantial merits of the disputes with the minimum amount of legal formalities. However, experience has shown that it's not always the case, and these cases in question are pretty good examples because they generally lead to the procedural processes that went through the CCMA. And I think let's start by looking at the background of the route that the Solomons matter took to get into the Labour Court. So let's start off by what happened at the CCMA. So firstly, following his dismissal from the Food Lovers Market, Mr. Solomons referred an unfair dismissal dispute to the CCMA, specifically to be resolved through conciliation. Now, the prescribed 30 days for the CCMA to deal or set down the matter for conciliation had lapsed. So Mr. Solomons then requested for the resolution of his dispute through arbitration. The matter was set down for arbitration, and 2 days prior to the date of arbitration, Food Lovers Market requested a postponement because one of their witnesses had tested positive for COVID-19. So Mr. Solomons and his legal representatives agreed to postpone the matter. They both agreed to postpone the matter, and they submitted the agreement to the CCMA. So naturally, as there was an agreement to postpone the matter, both parties then did not arrive for the scheduled arbitration, and the commissioner then refused to postpone the matter.
Hold up. But there was an agreement to postpone.
Correct. So, despite the fact that there was an agreement between the parties to postpone, the commissioner found that the submitted agreement was only signed by one party, and it was also filed within 7 days of the set down for arbitration, which goes against the CCMA rules for applying for the postponement.
Ooh, I'm pretty sure the employee must have been pretty unhappy about that.
Well, yes, and to make matters even worse, as the postponement was not accepted by the Commissioner then went and dismissed the matter.
Even when the witness had COVID-19?
It gets even better. So where the matter had then been dismissed, Solomons, obviously by the advice of his legal rep, then applies for rescission of the matter. And the matter was then considered by a second commissioner on paper, which means that they just took the submissions and made the decision based on that. The second commissioner refused to rescind the ruling of the first commissioner. So Mr. Solomons then went and launched a review of the rescission ruling at the Labour Court, and that's how the Labour Court matter came about. Okay, so let's deal with the review of the rescission ruling that went to the Labour Court and the many references in the review application to the Glencore matter, as well as obviously then dealing with the Solomons matter. So in the Solomons matter, the Labour Court firstly dealt with the need for a rescission as done by Mr. Solomons in the first place, which is very interesting because it has always been part of the normal course of process, i.e. a rescission as a result of a dismissal ruling. The court in Solomons referenced the Glencore matter again, and just to remember that both of these matters were both done by Judge Moshoana, where he concluded that Section 144 of the Labour Relations Act, which specifically deals with when a rescission application may be applied, says that it's specifically reserved for arbitration, awards, and rulings. However, this is interesting because it could be argued that a dismissal decision is a ruling. I mean, it even says dismissal ruling on the document that is used. However, Judge Moshoana states in the Glencore matter, which he then referenced in Solomons, that in his view, its appropriate label should be a statutory function. Thus, there can be no award issued nor a ruling issued, but a statutory decision made. And for the purposes of records and posterity, such an exercise of statutory power in terms of the CCMA rules must be recorded in a written ruling, and naming it a ruling is, in his view, a measure of convenience. And concluded that, therefore, as a dismissal ruling is not a ruling within the contemplation of Section 144, as interpreted by him, it is not competent for the CCMA Commissioner in the Solomons matter to have even entertained a rescission application. So let's get into the meat of the Labour Court judgment. Judge Moshoana states that in his view, the usage of the phrase in that section of the LRA to dismiss a matter is truly unfortunate, as the grammatical meaning of the word dismiss in law is to adjudicate, it's a cause of action, and as insufficient to proceed further in court because of some deficiency in law or fact, i.e. the matter then stops there. He continued with reference to Glencore that therefore the dismissal should be akin to a striking off or a withdrawal of a dispute, and reached a conclusion that in the context of Section 138 subsection 5, it means that the dispute is withdrawn or alternatively the other party is absolved of the consequences unless and until arbitration is requested again. So, the takeaway is that the CCMA has effectively not performed its statutory function as contemplated in Section 136 of the Labour Relations Act, which is to resolve a dispute through arbitrations. And if you read that again with Section 191 subsection 5 of the LRA, which is that they must arbitrate if 30 days have passed after a dispute has been referred, the dismissal of a matter is therefore nothing but striking off or a withdrawal of the dispute. So there were some important notes from the Labour Court judgment, and Judge Moshoana did make references that a application or a non-attendance that is willful and unexplained would result in a dismissal of the matter. And in making mention directly to the Solomons case, specifically with regard to that agreement that was referred to, he made reference that the agreement need not to be signed if acknowledged by both parties, where there's effectively a meeting of the minds. So nothing of the fact that only one party had signed the agreement, but it was fact that there was an agreement meant that the CCMA should have accepted that agreement. Now, another very interesting aspect is that Judge Moshoana also stated in obiter dictum that it may be necessary for the legislature to consider amending the section of the LRA and categorically state that the Commissioner may strike off the matter, as opposed to dismissing the matter and stating that such a legislative intervention may help employees rather than having to contend with applications for rescission and review and all that to get their foot back into the ring for the CCMA to do its function, which is to arbitrate the dispute. Okay, so for those seeking finality on the Solomon's order, as it was basically declared that there was no requirement for a rescission ruling, the application to review the rescission ruling was thus refused, because it was obviously said that the ruling issued by the CCMA was null in law. It was also declared that the decision by the CCMA to dismiss the matter by the first Commissioner, despite the fact in the face that there was an agreement, was irrational, invalid, and ineffective by law, because they did not show that the absence was actually willful and unexplained. So accordingly, the CCMA was then directed to re-enroll the matter for arbitration as soon as practically possible. So as a result of these labour court matters, and as mentioned, the CCMA issued a directive, and this directive is effective from the 15th of October 2021, so it's already in play. And this directive has been issued to all commissioners, who now have to then abide to a new process. And I just want to run through the process that's now going to be followed as a result of these cases. So, firstly, if the referring party fails to attend arbitration, or the arbitration part of a con-arb, the commissioner who is appointed must attempt to establish the reason for non-attendance. And if there appears to be a good reason for the attendance, the commissioner must record the reason on file and then redirect or direct the matter to be rescheduled for arbitration on another day. So it appears pretty subjective and does not actually call for valid proof. That's my opinion. However, if the absence is on the face of it willful or unexplained, or the commissioner does not accept the explanation, the commissioner may then exercise his or her discretion in terms of section 138, subsection 5, paragraph A, which we've been talking about, which is to dismiss the matter, and the matter will be removed from the roll. When the matter is dismissed, the commissioner must complete a prescribed form which states that the matter is removed from the roll and that the referring party was absent, and they may request for the matter to be re-enrolled in accordance to a prescribed procedure. The CCMA must inform the parties that the matter is removed from the roll by sending a copy of this decision to all parties. The matter will then be recorded as abandoned on CCMA's system and closed, which enables them to reopen it if a request for re-enrollment is granted, and the matter is then scheduled for or rescheduled for arbitration. And it is noted that a decision to dismiss in terms of that section of the LRA cannot be rescinded in terms of section 144 of the LRA, read with Rule 30 of the CCMA rules, and that's basically the crux of the Labour Court's decision.
So what is the prescribed format for re-enrollment, or the new way rather than rescission?
Okay, so applicants now need to complete and sign a prescribed form, which is titled the request for re-enrollment, and give reasons for their absence. A signed written request is sufficient, and it's not necessary for the request for re-enrollment to be made in affidavit or to be commissioned. So a request for re-enrollment must be made within a reasonable time, and the request for re-enrollment requires the referring party to explain the steps that they took to enroll the matter that was removed from the roll. This request for re-enrollment must be submitted to a provincial senior commissioner or a delegated commissioner to decide whether the referring party that was absent had provided the CCMA with a satisfactory explanation for their failure to attend the arbitration. So this should be noted, as a satisfactory explanation is obviously different to or opposed to good cause. And I believe that the feeling to demonstrate good cause probably imposes a standard that may be too high. So reasonable or satisfactory explanation of the failure to attend seems to be more in keeping with the tenor of the judgment that was then made by Judge Moshawana. They must also go and show the reasonable and timiest steps that they took to get the matter re-enrolled. And a commissioner is then obviously entrusted with considering the request. And when they do so, it must be noted that the commissioner who considers this request may do so on papers only, without submissions from an opposing party or without the need for a hearing. This is in line with the Labour Court rules, where such requests are considered in chambers by a judge, but we need to understand that this can be done even without the response or submissions from an opposing party. And in this, the Commissioner considers, with these other things, one of the primary things, which is a takeaway from the Labour Court's decision, whether the absence was willful and without explanation. So, if granted, the case will then be reopened and rescheduled for arbitration. However, if the CCMA refuse the re-enrollment matter, it will then remain closed on the CCMA case management system, and there will be no further processing of the case other than possibly for the purpose of a review application. We must remember that the decision on the request for re-enrollment is not a ruling but an administrative act. So accordingly, there's no scope for an application for rescission in terms of 144 of the Labour Relations Act, and the only remedy for a party who is refused re-enrollment, which is usually the employee, is to apply for review in terms of Section 158(1)(g) of the Labour Relations Act. If the party who had not referred the dispute to the CCMA, which is usually the employer, wishes to challenge the decision on the request for re-enrollment, then Section 158(1)(b) would apply of the Labour Relations Act, which basically means that the Labour Court may not review any decision during CCMA conciliation or arbitration proceedings before the issue in dispute has been finally determined. So you can't go and piecemeal bring in those review applications. The employer is going to have to wait until the end of the arbitration to then go and challenge the fact that it was re-enrolled in the first place. So in reflection and conclusion on this matter, it could be argued that the rescission process is akin to the re-enrollment process anyway. So it's pretty much same, but now with a little less legal formality. However, from an employer's point of view, it could be seen as a bit concerning, specifically due to the possibility of not getting an opportunity to oppose the re-enrollment request and have the matter concluded where a party doesn't arrive, which basically means that we then have to rather deal with the matter being simply struck off the roll, and the consequences of that means that the cost implications and business interruptions of having to bring witnesses back again and available to testify at proceedings just simply getting re-enrolled at another date is quite real. But as matters now stand, simply being struck off the roll or abandoned may leave employers sitting indefinitely on a low-cost airline with an open seat next to them, just hoping and waiting that it never gets filled. But thank you, Yas, for your involvement in today's episode, pushing buttons as well as asking questions.
Well, it's always a pleasure letting you know that I'm more than just a button pusher.
So, just before we end this episode, a reminder to get in touch on social media or drop us an email at sesk@labornet.com. Give us your input and let us know what topics you want us to discuss. As always, it really helps us improve and push out quality content that you want to hear. So, from myself, BGD, and Yas, till the next show, stay safe and cheers.
Stuff Employers Should Know was proudly brought to you by LaborNet, management's ultimate HR solution. For more episodes from Stuff Employers Should Know, go to Apple Podcasts, Google Podcasts, or wherever you play your favorite shows. Case law or statutes referenced in the podcast are current at the time of recording.